What is the legal definition of disability? Hi, I'm Mark Whitehead, a board-certified disability attorney and author of the ebook Disability Insurance Policies: How to Unravel the Mystery and Prove Your Claim. Long-term disability insurance companies are notorious for denying legitimate claims based on obscure disability definitions contained in the policy. There's no one real legal definition of disability. Every insurance company has a different definition of disability, as does the Social Security Administration and the Veterans Administration. The term disability is defined by the insurance contract. Usually it's something along the lines of, due to sickness or injury, the employee is unable to perform the material and substantial duties of his or her own occupation. However, most policies shift the definition to a more difficult any occupation standard after a period of time, usually 24 months. The insurance company gets to define disability, interpret the terms of the definition, and decides whether or not a claimant is disabled. The insurance company also decides whether or not a claimant will receive benefits. This creates an inherent financial conflict of interest. Because the insurance company decides whether or not a claimant is disabled, they will use their own employees, either a nurse or an in-house doctor, to review a claimant's medical records. Many times, these in-house consultants will have a different opinion than the claimant's own treating doctor. The insurance company will state that the claimant's doctor's opinion is not supported by the medical records. The Supreme Court has looked at this issue and decided that the treating physician rule, as used by the Social Security Administration, does not apply to disability insurance determinations. The treating physician rule says if a treating doctor says a claimant is disabled, that opinion is entitled to great weight. In private disability plans, the U.S. Supreme Court has held that a claimant's doctor's opinion that the claimant is disabled should be taken into account as a factor in the insurance company's determination of disability, but it's not binding on the insurance company's determination. So what if the Social Security Administration says that you're disabled? Isn't that enough? For a person under the age of 50, a Social Security Administration definition of disability is actually a tougher standard than a long-term disability insurance definition, because a claimant must be unable to work at any occupation in the national economy. But because Social Security rules differ slightly from the disability insurance companies, the insurance company will ignore an award of benefits by the Social Security Administration by stating that the rules are simply different. But what if the long-term disability insurance company helped you get your Social Security disability in the first place? Well, the insurance company is more than happy to help a claimant get Social Security disability benefits because it helps them financially. The insurance company contracts with another company that represents claimants before the Social Security Administration. The insurance company will reduce a claimant's LTD monthly benefit by the amount that claimants receive from the Social Security Administration, and will even demand that the claimant pay back the insurance company the back benefits received from Social Security. For more information on this topic, check out my free ebook, Disability Insurance Policies: How to Unravel the Mystery and Prove Your Claim. Visit www.disabilitydenials.com for a free downloadable copy, or call 1-800-562-9830 to discuss your particular disability issue. I'm Mark Whitehead. Thanks for watching.